My name is Andrew Cederdahl. I'm an Equal Justice Works AmeriCorps Elder Justice Fellow. Again, the longest title I think that's anyone's ever had, ever. I work in the legal aid office on our hotline. I'm focused on elder abuse issues. I am going to be talking today about basic legal planning issues. I think this is another really important thing that everyone needs to engage in. I do think it can help us avoid abuse, generally speaking, although I'm not focused on that in this particular talk. Today I'm going to talk about two different types of planning. We need to be planning for our financial futures. We also need to be planning for when people might have custody over us, if we can no longer make decisions or need help making decisions, things of that nature. If we can have some input ahead of time, that's really going to help preserve our intent and our well-being. So I really think everyone needs to be doing it early on before it's too late, where we get to a point where we can't really make the decision anymore. And I think the goal in this sort of legal planning, in my mind, and I think in the legal system's mind, so to speak, is to balance safety and well-being with self-determination. Of course, we all want to be able to make our own decisions for as long as we possibly can, assuming that we are able to do that. But when that cannot occur for some of us any longer, we still want to make sure that we have input into our direction in our lives and that we're still safe and well. So legal planning helps us to accomplish that. So I'm going to talk about financial powers of attorney. I'm going to talk about representative payees, conservators, explain what these things are as with regard to our finances. And then I'm going to talk about custody over the person. So those non-financial personal decisions that are made on our behalf when we're not able to make them. That would include healthcare powers of attorney. I'm going to briefly touch on an out-of-hospital DNR order, explain what that is, living wills and guardians. And then I'm going to end with a scenario to kind of explain if we get our legal planning done, what that can do for us, and if we don't get our legal planning done in advance, what that can do to us as well. So let me start with financial powers of attorney. I think everyone has a general idea of what this is, but I'm going to explain it a little more in depth. This is a written legal document in which a person gives another person the authority to act, generally in financial matters. Okay, so and the terms we use when we're talking about powers of attorney, financial powers of attorney, are principal and agent. Okay, so the past term used to be attorney in fact for the person that you were giving the power to. So, older attorneys or attorneys who aren't up to date on the new language might be using that term. But the term that we use now is principal and agent. Principal is the person giving another person the power to act. The agent is the person who has the authority. I kind of remember it like a secret agent's on a mission. The agent's on a mission for the principal to act for the principal. That's how I remember it. So whenever I refer to principals and agents now, you know what I'm talking about. There's another phrase that I just want to briefly explain what it means. A lot of people have heard it. They don't know what it means. What is a durable power of attorney? What does it mean when a power of attorney is quote-unquote durable? Well, that just means that it's not terminated by the principal's incapacity. Okay, so it just means that if a principal executes a power of attorney, let's say when they're 30 and completely healthy, nothing's wrong with them, and then later when they are 75, there's some sort of issue that renders them incapacitated. That power of attorney, if it were instantly in effect when they were 30 and they executed it, would continue to be in effect while they're incapacitated. That's all it means. In Iowa, if the power of attorney document that you execute does not say it's durable, it's assumed to be durable. Okay, so that's the law. So if you don't want it to be durable for some reason, I don't quite understand why you wouldn't want it to be, because usually the point of having a power of attorney is to have someone to help us when we can't make decisions or we need help making decisions. But if we didn't want it to be durable for some reason, we would need to explicitly put that in the document. Okay. And when I say incapacity, let me explain that a little bit too, because I'm going to be using that term a lot here. That's the inability of an individual to manage property or business affairs because of any of the following reasons. Primary one is that an individual's decision-making capacity is so impaired that the individual is unable to make, communicate, or carry out important decisions concerning the individual's financial affairs. It could also be if that person is detained or incarcerated in a penal system, and it could be if someone's outside the United States and unable to return. But the biggest one that often happens is the first one. That's when decision-making capacity is no longer there. The most obvious example, person's in a coma. That person obviously can't make, communicate, or carry out anything, let alone a financial decision. Another example would be person has an onset of a mental illness, let's say dementia. Now, I don't want to say, just like Tanya said earlier, which was completely right, that just because you have dementia or have been diagnosed with it, that you cannot make decisions any longer. There's obviously a continuum of every mental illness and severity, different severity. So it doesn't mean that just because you have a mental illness that you no longer get to make decisions. Okay, that's a common misconception I'm going to talk about later. But if it's a mental illness that is so severe that it's obviously interfering with our good judgment, that is going to be a time when we could say that a person has been incapacitated. So let's say, for example, a person says, I have a piece of land that's worth $10,000. I'm going to sell it to this buyer for $10. I'm just going to sign whatever the buyer puts in front of me, and just give it to them for $10. It's obviously not a gift. It's not a family member, nothing like that. That would obviously be not a good financial decision if we're talking about an arm's length transaction, or what's supposed to be an arm's length transaction, meaning, again, not a gift. And that would be an example where we could say if that person had dementia and they were doing something like that, they were incapacitated. They're not making good decisions. Another example, a person has Alzheimer's, let's say, again, not just diagnosed with it, but very severe Alzheimer's. He didn't pay his bills for 4 months straight. He didn't realize he wasn't paying his bills. He was reminded to pay his bills. He still didn't do it. Family member finds out, talks to him. Person's not even able to do it. We could see that person is not able to carry out really any of his financial affairs. That would be an incapacity. It wouldn't be that a person's a little bit forgetful or anything like that. So again, I would echo what Tanya said earlier, because we need to be respecting people's agency and their ability to make decisions for themselves when they are still able to do that. So let me talk about what a financial power of attorney can do generally. First, I just want to point out there's no petition to a court whenever we have a financial power of attorney. This is a document that you can prepare with you and your attorney, and you don't have to go to court to do it. The court doesn't have to bless who the agent is for the principal. It's really the principal's choice on that. So there's no court that's going to come in and order a financial power of attorney. Okay, that's just not how it works. So what a power of attorney can do, they could handle bank accounts, including safety deposit boxes. That would mean they could modify an account. They could contract for services with the bank. They could withdraw and transfer money. They could receive banking statements. They could apply for debit credit cards. Pretty much anything that the principal could do, the agent can do if he has a valid power of attorney. They could do real estate transactions. They could acquire or reject an interest in property on behalf of a principal. They could sell, convey, quitclaim, partition, develop, lease property. It's a lot of power right there that they could have. They could mortgage an interest in property as security to borrow money. They could manage, conserve an interest in property. They could obtain liability insurance, casualty insurance, pay taxes, regain possession, protect an interest through litigation. So there's a lot of things they could do with real property just under that. They could borrow money on behalf of the principal. They could pay the principal's taxes. So they could prepare, sign, and file the state and local taxes that they file. They could exercise certain elections, if you're going to take certain elections in your taxes. They could act for the principal in front of all tax matters. So if there's some sort of proceeding in front of the IRS because there was some dispute with the IRS about taxes, that power of attorney could appear before the IRS and vie on behalf of the principal. The principal could assert and maintain a claim in litigation. So if that principal is being sued or suing someone else, and then the power of attorney takes effect, the power of attorney can basically make the decisions in that lawsuit. They could intervene, seek garnishment. Let's say the principal already won a lawsuit, but now can't collect because he or she is incapacitated. Power of attorney could come in and get a garnishment against that other person that we have the judgment against. So it's pretty broad. Seek appellate review. They could appeal a decision, pay a judgment. If the principal has a lawsuit against them and it needs to be paid, the agent could pay that lawsuit off. So as we see, and this is just some of the stuff, I mean, there's more. This is a very broad power. This is something that, you can basically do what the principal can do. So we really need to make sure we trust who it is that we give this to. A lot of people kind of flippantly give this out. And it kind of boggles my mind sometimes when I hear who they're choosing to be their financial power of attorney. This is a power that we really have to safeguard and put a lot of planning and thought into, and not just give out haphazardly. Now, I do want to mention, so those are all the things that it could be that a financial power of attorney could do. Principal typically is going to give all that power. In my experience, they're just going to say, I trust this person fully, as they should. But it's possible in that document to only give the power to do certain of those things that I said. So there could be a general financial power of attorney where it includes all those things and more that I've already mentioned, or it could be that the principal only gives certain powers. So the principal could say, I want you to be able to go to my bank and withdraw money and pay my bills, but I'm not comfortable with the power for you to sell my property, for example, or transfer my property. That would be probably one of the more common ones. That's possible, okay? And in the document that's commonly used in Iowa, you can specify pretty easily with generally just check marks what powers you would like the agent to have on your behalf. So let me talk about some of the duties that a financial power of attorney has. This is another thing that I commonly run into on our hotline. And it's really unfortunate because a lot of people simply don't understand what a financial power of attorney has to do. They think that financial power of attorney just gets to do whatever they want, and they're not accountable to anyone. That's simply not true. So here's several duties I have listed out here that a power of attorney needs to do if they accept that appointment. First, the power of attorney, the agent, has to act in accordance with reasonable expectations to the extent actually known. Okay, so if this principal is incapacitated and an agent is acting on behalf of that principal, we expect that agent to act with, to the extent they would know that the principal wants them to act. So people are particular about what they might want done. We don't expect that agent just to make any decision that they want. They really need to be thinking about what the principal would want. Okay, so it really depends on the facts what that could be, but it's something that people don't quite understand. They think they can just make the decision. They really need to be thinking about the principal's intent and expectation. Second thing is that the agent needs to act in good faith with care, competence, and diligence. This is another thing that is a huge misconception. People think that if I have a power of attorney, it's like, the principal's bank account is my bank account. That's simply not true. Okay, this is, you need to act with good faith. That means if you're using money, the principal's money, it needs to be for the principal's benefit, not your benefit. Okay? The agent, this is another huge problem that I encounter on the hotline. The agent needs to act within the boundaries of the powers granted in the document. Okay, so if the document says no transferring real estate or no doing XYZ, the agent can't do it. Okay, or if the agent is trying to do something that a financial power of attorney can't do. Tanya mentioned that, which I'm going to mention again later, saying you can't have visitors. I'm just your power of attorney, but I'm going to tell you who can visit you in a nursing home. That's not legal. That's not the role of a financial power of attorney. Okay, that's a common misconception. Another thing is that the agent needs to act loyally to the principal. So their loyalty needs to be to the principal, not anyone else, not another business interest, not the agent's interest, the principal's interest. They need to not create a conflict of interest that impairs the agent's ability to act impartially or in the principal's best interest. Now, the law does say that just because the power of attorney does something that also benefits the power of attorney in some way, that doesn't necessarily mean that they're not acting in good faith or they're creating a conflict of interest. But that's going to be pretty scrutinized if that gets looked at later. So I would personally say that that's probably not a good idea. We need to avoid that appearance of impropriety even. So I would not encourage people to do things that look as though you're doing it for your own good. If you're the power of attorney, that it's just benefiting the power of attorney and not the principal. Okay. The other thing we need to do is keep records and receipts. This is probably the biggest thing that I see over and over again that powers of attorney simply do not do. They don't even read the document that they've been given. They say, oh, okay, I get to make every decision ever. I get to tell my mother or father, or whoever it is, who can visit them, and I'm just going to use their account as my personal bank account. That's not how it works. You need to be keeping records, receipts, disbursements, transactions, because the agent or the agent's fiduciaries or other people associated with the principal, depending on what the document says, have a right to request an accounting of that power of attorney. So, if there's any question that someone's being abused, for example, and I, as the attorney of the principal, say, Mr. Power of Attorney, I would like you to tell me how you've been spending the principal's money, you need to be able to account for that. I need to see receipts. What is this cash withdrawal that happened 2 months ago? And the principal says they don't even know where that money went. We need to be very careful about that. I don't mean to scare people into not serving as powers of attorney. We need that. Okay, but we need to be doing it responsibly, and this is a duty that's clearly in the law that we need to be keeping our receipts. So let's keep that in mind. Another thing they need to do is cooperate with a person that has authority to make healthcare decisions. So if we have a medical power of attorney who's saying, we need to go this course, we need to, take this course of action with healthcare, the power of attorney needs to arrange to get that paid, for example. The last thing I'll mention is that the agent needs to preserve the principal's estate plan. Now, I know a lot of people that makes them nervous because they worry about their liability. They might say, well, what if I make a mistake? I'm trying to do the best I can for my principal. I'm not a financial expert. I know the basics. I can get their bills paid, but I'm worried about preserving their estate plan. What's my liability? Just so everyone knows, if you act in good faith, if you're a power of attorney agent, you act in good faith in trying to preserve that estate plan, you're not going to be liable for that. If you act with care, competence, diligence for the best interests of the principal, you're also not liable solely because you also benefit from something. Remember, I kind of mentioned that earlier. So as long as I would caution people to do things as a power of attorney that look like they just benefit the agent and not the principal. But it's under law. You're not going to be liable if you're acting in good faith in those things that I've already laid out. Generally, it's pretty clear when that's not the case, but sometimes it's arguable. So we need to avoid that appearance whenever it's not clear. Some advantages to having a financial power of attorney. It's relatively inexpensive. If that's the only thing you're going to an attorney to get is a financial power of attorney, going to be relatively cheap as far as legal costs go. It's a flexible document, so we can say in that document, as I mentioned, what sorts of powers the agent can have. If we want to give them carte blanche, all power to do whatever they want to do, or if we want to say, I don't want them transferring my real estate, but they can access my bank, that can easily be reflected in the document. You can also say when it comes into effect. So you could say, I only want this document to come into effect upon my incapacitation. Commonly, that would be a written doctor's note that says, I, as a doctor, in my medical opinion, think that this person can no longer make financial decisions. Once someone gets that letter, then the power of attorney would come into effect. So it could just be a backup plan where maybe the principal wants to make their own decisions for as long as humanly possible, and they just want a backup in case something happens to them, or if they just want to give it now and they just want someone to help them out because they want it for convenience reasons. That would be something that you could decide and do in your document. Again, the agent owes the principal certain duties. This is not a free pass for the agent to plunder the bank account of the principal for themselves. They need to be acting on behalf of that principal and in good faith with competence, diligence, all those things I mentioned. And lastly, this is not as invasive as a conservatorship, which I'm going to talk about pretty soon here. Some disadvantages, I've already mentioned that, a few of them, but potential for abuse. There's no court supervision. Okay, so there's no accounting requirements insofar as no court is going to be reviewing the transactions that the agent engages in. So if the agent takes that power of attorney to a bank, withdraws a bunch of money, no court's reviewing that. They should be keeping receipts, technically, but commonly that doesn't happen if abuse is happening because it's hard to figure out what's going on, and that's usually on purpose by the exploiter. But they need to be, they should be keeping those receipts, but commonly they aren't. So it's really hard to know sometimes what has been done with that money, where that money has been spent. So there is that possibility that people can be exploited with that document. The other possibility is if they revoke the document, sometimes other institutions may not know that. So that revoked document, could be still sitting in the abuser's, I don't know, wherever they keep their papers. They take that document to another bank, open a credit card with it or something. That second bank they went to has no idea that it's been revoked. It doesn't mean that we can't later try to hold that exploiter liable for that sort of behavior, but it can happen because the bank doesn't know it's been revoked. Okay, so there is that possibility too. And another thing that I kind of have already mentioned, the agent sometimes doesn't even understand what it is they can and can't do. Okay, so they think that this is some sort of pass where they get to decide every little thing in the agent's life, and that's simply not true. Okay, but sometimes the principal doesn't know that, so they abide by what the power of attorney is telling them on some non-financial matter. So just simple misunderstanding of what that power entails is very common. So I'm just going to mention that again because it's so important. If an agent says, Mr. Principal, you have to live here, and all that agent is a power of attorney, not a guardian, not a power of attorney, a medical power of attorney, nothing like that. They don't have the ability to do that under a power of attorney. That a power of attorney is limited to financial matters. Okay. Any other non-financial matter, you could think of any sort of thing where the agent is saying you need to do this or that. If it doesn't involve finances, they don't have the power to say that. And we can always revoke the power of attorney if we don't like what the agent's doing. Okay, so an agent, another thing I want to mention before I move on is that just because an agent can make a decision for us on our finances doesn't mean we can if we're the principal. That just means that an agent can act on our behalf, but it doesn't mean we don't have agency as well if we're the principal. So if you have a power of attorney and that power of attorney agent is going and doing things on your behalf, doesn't mean you can't also go to your own bank and withdraw money. Okay, a lot of people misunderstand. They think they've given away their agency, their power to do anything. That's not true. Okay, you can still do whatever you need to do. It's just if we're only talking about powers of attorney. I'm going to talk about guardians, conservators later. That's a different case. But if we only have a power of attorney, we still have agency to make decisions. Now, let me talk about representative payees. So that's it, some basics about financial powers of attorney. Let me say what a representative payee is. That is an individual, agency, or institution appointed to receive Social Security benefits. Okay, so the terms we use here, it's not like a power of attorney. The legal terms are representative payee, that's the individual, agency, or institution that's been appointed. And then the beneficiary, that's the person whom the funds benefit. It's kind of like the principle of the power of attorney, except we're talking about representative payees. So those are the terms that we use. Who needs to get one of these? Well, someone who gets Social Security benefits and is not capable of managing the benefits. So again, we have an incapacity here. Someone is in a coma. Their only income is Social Security. There's some dispute with Social Security that needs to be cleared up. Someone is going to need to be appointed representative payee to be able to do that on behalf of the beneficiary. Another, obvious example is someone with a mental illness that cannot manage their own funds. The mental illness is the reason why they can't do it. Not just a minor mental illness that doesn't interfere with our ability to do that, but a major one where we cannot handle our finances. That is going to probably need to have a representative payee appointed. Now, I want to mention this. If you already have a power of attorney, that power of attorney does not get to manage your Social Security automatically. That's another common misconception. People get really angry because they go to the Social Security Administration and they say, I'm a power of attorney. Why won't you let me talk about my mama or father's case, of overpayment or underpayment? I'm trying to figure out what's going on here. I'm trying to help that person. And they say, I'm sorry, but you're not the representative payee. Those are two separate things. If we're talking about Social Security Administration funds, we need to have and we need help. The beneficiary cannot handle it, cannot talk to Social Security about it. We need a representative payee. Let's keep that in mind because they're not the same thing. How does that come about? How do we decide that a representative payee is needed? Well, typically someone's going to alert the Social Security Administration to, person's in a coma, person is so mentally ill that they cannot manage their finances right now. Dementia has progressed. They can't do their bills, whatever it might be. Social Security Administration is going to do an interview with the beneficiary, the person who's allegedly mentally ill, can't handle their finances, and or their physician to figure out what is going on. And then a beneficiary is probably going to be appointed. They like to appoint family and friend, people who are close. Sometimes a big problem right now is people who don't have friends or family and they need a representative payee. I mean, sometimes they can go to an organization like Salvation Army or something like that, but those services are quite limited. There's not a lot out there for these people, especially if their only income is Social Security. They're very poor. So that's a huge gap right now that I've seen. People need these services, but there's no one to do it. Okay, but typically they're going to want family and friends to do that role. So there are some responsibilities, just like with everything, just like with powers of attorney. The representative payee is going to need to provide first for the beneficiary's essential needs. Okay, so that's going to be shelter, food, clothing. That means if we're only getting $700 per month and rent is $500 and food is $200, the representative payee should not be buying a television first. They should be covering the rent, buying the food. So once we get our essential needs taken care of, shelter, food, clothing, things of that nature, then we can prepare for other things. We can pay our debts. We can budget for the future. We can buy those things that we don't technically need but might just want, like a television, for example, or whatever it might be. They need to be handling the essentials first. Some advantages to having a representative payee, again, less restrictive than a conservatorship, just as a power of attorney is less restrictive than a conservatorship. The management is going to be limited to Social Security benefits, so the power of attorney can handle other non-government income that's coming in, but if we're talking about Social Security, the representative payee is going to be handling that, and that's all they're going to be handling. So you could technically have a power of attorney and then a different person be your representative payee. I think that's a little confusing and might not be very efficient, but it's possible. The last advantage is that there is some insight. So the representative payee is going to be filing reports with the Social Security Administration about how money is being spent, unlike with a power of attorney who's technically only supposed to be keeping records, but no one is really checking that until there's an issue where it might be too late. Now, I will say I've not seen this form yet in person, but I've heard that it's quite vague. So this is not going to be a very, very complex form that is being filled out. It's going to be generally how much money was spent kind of thing, not itemize every single purchase that was made. So there is still that potential for abuse, as I'll mention later, because it's pretty easy to write down on the report what has been spent and not if you don't have to itemize every little transaction. So I just point that out. The other disadvantage is that the beneficiary cannot directly use benefits after a representative payee has been appointed. Only the representative payee can do that. So that's different from a power of attorney. Remember I said with the power of attorney, the principal still can go to his or her own bank and withdraw money, even though another person can also do that. If you have a representative payee, that's not the case. Because the Social Security Administration has determined that you're not able to manage your finances. So why would they let you then use your money? You're not capable of using your money. That's their rationale. So that is a little bit different. Okay, and a lot of people get a little annoyed with that. I think sometimes rightfully so, but that is the rule. And then again, there is that potential for abuse. The reports that they have to file are pretty vague. They're not extremely complex. You don't have to itemize every little thing, to my knowledge. So, there is that potential. Another potential is that, if this person is incapacitated for some reason, mental illness, something like that, and the representative payee might be their only real contact, the family friend or just acquaintance that they have because they have no one else to do it. A lot of times no one's going to know whether they're being abused or not. No one's going to find out because no one has any contact with them. So that's just a kind of a thing that happens typically with abuse. So that's representative payees. Those are the less intrusive forms of having a substitute decision maker on our behalf. I'm going to talk about conservator. This is the most intrusive. Okay, this is someone, unlike a power of attorney, where I said, you just go to a attorney and they do a document for you and you kind of decide what you want to do and fill out the document yourself and it's all informal outside of court. This is where a person's been appointed by a court to manage someone's finances. The terms we have here are conservator and ward. So I know it's a little annoying that we have different terms for different people with all these different categories, but those are the terms, so if you see them now, you know what they mean. Conservator is the person who manages property because they've been appointed by a court to do so, and the ward is the person whose property the conservator manages. Okay, so again, this involves petitioning a probate court, unlike a financial power of attorney. What can a conservator do with the property of the ward? Well, they can do pretty much anything that the court order tells them they can do. Now, that can include managing bank accounts and financial records, like I said, just like with the power of attorney, filing income taxes, making bill payments, settling lawsuits, making sure the lawsuits are going as needed. So it could be quite a lot, but they are technically required to have findings of fact showing why that broad power is necessary for that particular ward. So they're supposed to make it as limited as they can because we do value, generally speaking in our society, the ability for someone to make their own decisions for as much as they can. So it's supposed to be limited where it can be limited. But if this person is so incapacitated that they can't make any decisions about their finances, they're probably going to get all the power that they need to manage those finances. So I kind of already alluded to this, but the conservator should be appointed when a person is so impaired that the person's unable to make or carry out important decisions about financial affairs. So that could, again, be a severe mental illness. Doesn't mean that everyone with a mental illness can't manage their own finances, but obviously it's a spectrum. Some are worse than others. If it's really interfering with their ability to do so, they're saying, I'm just going to go out in the street and dump my $1,000 this month on the sidewalk because I don't know, for some silly reason, that would obviously be an impairment that is we need to address with a conservatorship. Because that person doesn't have we're assuming at this point that person does not have a power of attorney to help them or has revoked it or something like that. There's some dispute about whether someone can help them. They don't want the help. They don't think they need the help because they're delusional or very, very mentally ill, and they don't even recognize it, let's say. We need to have someone petition to say, Mr. Judge, we need to have this situation taken care of. Someone needs to be appointed, whether that ward wants it or not. Some advantages to having a conservator. There is some oversight. This is not like a power of attorney where a court's not even looking at anything that's being done. This is A conservator is going to have to file reports with the court about how money is being spent, so there is going to be some oversight. It's more authoritative than a power of attorney. Sometimes there are situations where family is fighting about who can do what, and maybe a power of attorney has been revoked or something like that, and the bank is kind of in the middle of it, and they see this document. They don't know whether this power of attorney is still valid or not. It's very, we could all imagine certain scenarios where the banks and other institutions are going to be confused about what's valid and what isn't, because it's such an informal thing. It's just a document that you filled out with your attorney, and there's no court. With a conservator, if you have an order that you're a conservator, that is a lot more authoritative. You take that to a bank, you say, bank, I am a conservator, been appointed by a court. The bank is going to be a lot less likely to question what should be happening. Okay, so we're going to avoid some of those things that can pop up when we have contentious family disputes and things of that nature. It's going to be more authoritative when we go to a bank. Disadvantages, as I keep mentioning, it's very intrusive. The reason for that is, in my example I said where someone just says, I'm just going to give out my $1,000 I got this month on the first day of the month. I'm not going to provide for my own well-being. I'm not going to pay my rent, my food. I'm just going to give it to the first person I see on the street. That's clearly, let's say a doctor has said that's because that person is mentally ill. A conservator can tell that person, you're not going to do that. I'm sorry, but you're not going to do that. And it doesn't matter if the ward agrees with that or not. The ward can't do it. The conservator is going to be able to control those sorts of decisions. Okay, so that obviously is very intrusive because we want to be able to have a say, and the conservator should be listening to what the ward wants, but does not have to agree with that ward on these sorts of financial considerations. We can't revoke this. Okay, so if we have a court order in place and that conservator is not doing what the conservator should be doing, something like that, the ward wants another conservator, thinks that there might be one that would be better suited for that ward, we're going to have to petition a court for that. Okay, you're probably going to have an attorney. I mean, you could do it yourself, but it'd be a little complicated if you're not an attorney. So you're probably going to have an attorney. You're going to have to pay an attorney. The money for the attorney might come from the ward's estate, the court's going to have to bless that, whatever the ward wants. It's also going to have time and expense involved in it. If we have a institution that's going to be a conservator, there could be a fee for that, unlike with having a power of attorney where you're not paying someone to do it for you. With this, there could be extra fees. So that's all of the finance. So that's the most intrusive. I've gone through the least intrusive to the most intrusive forms, substitute decision making. Now I'm going to talk about healthcare powers of attorney. Healthcare power of attorney is a written document where one person gives another person the authority to make healthcare decisions when the person's unable to make those decisions. Terms here are principal and attorney in fact. Again, that's very confusing because with power of attorney in fact is the old term. Now we use principal and agent. Well, here we still use attorney in fact. It's kind of silly, but it's what we do. There is no petition involved here with a healthcare power of attorney. This is another document you can do with your attorney outside of a courtroom. What can they do? They can make healthcare decisions according to the principal's wishes. So, and if they're unknown, the attorney in fact has to act in their best interests. So you can put in that document what you would want if there's some sort of thing that you're dealing with, and you know what you would want to happen to you if XYZ happened. You could put that in the document, or you could just give someone that power if you know them really well and say, well, that person would know what I would want, and that would be sufficient too. They could do things like choose a long-term care facility for another, hire home care providers, decide a course of treatment if there's different options. There might be different risks, different potential benefits to certain courses of treatment, and that healthcare power of attorney would be tasked with deciding those sorts of things. Advantages, not as invasive as a guardianship. This doesn't involve any sort of petitioning the court. You don't have to pay an attorney hundreds of dollars for several hours, possibly dozens of hours if it's contested, to do a guardianship in court. You just do the document. The attorney, in fact, has to follow the wishes that are included in the document. So if you have something very specific that you want done, you put it in the document. The attorney, in fact, has to follow that. And this can also be revoked by the principal, even orally. So whenever you revoke a financial power of attorney, you got to do it in writing. With a healthcare power of attorney, you can orally say, I revoke this. If you're in a hospital and there's any question and you say, I revoke this, or I rescind it, or you say any sort of language that could be interpreted as revoking it, they're going to revoke it. It's not going to be valid anymore. Because for obvious reasons, we're dealing with the health of another person and their decisions on what they want done to them. So that is an advantage to the person who is giving that power to someone else. Disadvantages, again, no court supervision. There's no courts involved. There could be potential for abuse. I don't think it's very high, but there is potential. So we need to be making sure that we're communicating with whoever we're appointing to be our medical or healthcare power of attorney, and we need to be communicating what we would want with them. Let me just mention, this is only one slide on this. I'm just going to mention it because some people are interested in it. Out of hospital do-not-resuscitate order. So this is something where a healthcare provider may withhold or withdraw resuscitation outside a hospital, consistent with a do-not-resuscitate order. So if someone is in the hospice care, they're not in the hospital anymore, they're terminal, they're going to pass away soon, and they don't want an ambulance to come and haul them back into a hospital because they know that they're terminal and they've accepted that, and their choice is that they would not want to be resuscitated if they're about to pass away or have any attempt on that, then they could do this order so that no one's going to call the ambulance and then take them back to the hospital where they don't want to be. Okay? So it does not mean that they're not going to give you comfort care and pain relief if you have this at a hospice or wherever you are at home or whatever. They're still going to provide for that sort of thing. It doesn't apply if there's a sudden accident or injury that's unrelated to the terminal condition. So, for example, if let's say they're dying of cancer or something like that, and they fall down and break their arm, well, they're still going to treat your arm that you fell down and broke. It's just that, so that's not related to that's just an example. That's not related to your terminal condition. It can be revoked anytime the patient or whoever the patient specifies in the document communicates an intent to revoke. So again, this is so important. We obviously don't want to have any miscommunications here. People change their minds. We want to make that as easy as humanly possible. So unlike a financial power of attorney that requires written revocation, with an out-of-hospital DNR order, a person could say, I revoke that, and then that would not be in effect anymore. And if there's any uncertainty, as we could expect here, to sometimes happen, there might be confusion, they're going to provide that resuscitation, because obviously we don't want to screw around if someone's about to die and we don't know what they want. Okay, the resuscitation is going to be provided if there's any question. So I just mentioned that because that's something that people might be interested in and having if that's something you want. It's very similar to what I just talked about, living wills. This is a document that directs someone's doctor to withhold or withdraw life-sustaining procedures that could prolong the dying process. So if you're in the hospital, you go to the hospital for something you didn't expect one day, and you're the kind of person who would not want to just be kept on life support if that's what it came to. If you would just want to have that sort of thing taken away from you so you naturally pass away. If that's what you want, you would want to have this document in place, okay? Because this is going to save us a lot of stress and heartache and money for our family if we can get this done. If this is what we want, we can have our wish be very clear and explicit and direct our doctors what to do. It's only going to take effect when a patient is in terminal condition. So, you don't get to just do a living will and then, if you're perfectly healthy and you have some random health problem that's not terminal and then say, oh, I have this document, don't treat me. That's not how it works. It has to be terminal, and it has to be that without life-sustaining procedures, it will result in death within a short period of time. Okay, so like we're on our deathbed type situation. It's not going to be, this kind of weird, like I fell and broke my arm and I have terminal cancer. Oh, we're not going to treat that. You have a living will. That's not how it works. It has to be death is within a short period of time. And the doctor is going to determine whether a patient's condition is terminal or not. Okay, not a family member or someone else who might have an interest in that or something like that if they're exploiters or abusers or something like that. So the doctor is going to determine that. Now, there are some priorities I'll mention. So if you don't have this living will to say who, that this would happen if I became terminal and there was a, life-sustaining procedure, and the question was, do I want that or not? The first person who would make that decision if we don't have a living will is our durable healthcare power of attorney that I already mentioned. So if you have a durable healthcare power of attorney, that person could make that decision. If you have an appointed guardian, that would be second. Okay, so it's kind of interesting. I'm going to talk about guardianships next, but if you have this done, that's going to trump a guardian. That's a court-appointed person who's going to make decisions for us. And if you don't have a guardian, that's fine. Then it would be your spouse. If you don't have a spouse, it would be your adult child or a majority of adult children reasonably available for consultation. Now, as we can see, if we want a living will and we don't have one, and let's say we get down to 4, we don't have a spouse, we don't have a guardian, we don't have a durable healthcare power of attorney, we could see how this could create some real stress within our family. Because what if they can only find one child, but we have 3 and they're spread out or something like that, and they don't maybe get along and they have different opinions on what you would have wanted? Well, now they have to make this decision. And they might be arguing back and forth, or two out of the 3 might make the decision without the third because they couldn't find the third in time or something like that. We could see how that could create some dissent within our family and some stress that we might not want to create. And it's very simple to get rid of that if we just have our living will in place already. Okay, so this is why I'm doing this talk. I'm trying to get people to think about this ahead of time so that we can help avoid those sorts of situations that we don't want our families to be in. The other thing would be the fifth order priority would be parent or parents if both are reasonably available. Same situation as what I just mentioned. What if your parents are divorced? It has potential to result in things we don't want. And then adult sibling. Again, you might not get along with your adult sibling, or your adult sibling might not know what you would have wanted, and then they're sitting there agonizing about what you would have wanted. Well, we can tell everyone what you want by doing a living will. Some advantages to having one allows you to decide important questions in advance. So you can do this way in advance. No one has to screw around with trying to get your family, find your family wherever they are, if they're all spread out or whatever, and then try to have them guess about what you would have wanted if you didn't discuss it with them. We know if we have this document what you want. It's clear. It's in the document. We can avoid all of that contention. It's very easy and inexpensive. If this is the only thing that you're getting from a private attorney, it's going to be pretty cheap, generally speaking. As far as legal things go, it's pretty inexpensive. As I said, it's going to lessen strife and stress among our family and friends because it's going to tell us clearly what we want, and we don't have to have that ambiguity or argument with each other about what that might be. And as I said, statutory priority is not going to be the best fit for every case. I mean, this is generally what we think people might want if we don't have it, that order that I discussed. But it's not perfect because we're all different. And we all have different situations. We all have different families, different relationships. So if we want to just take that out of that sphere of contention and just decide, we will probably want to have to get our living wills done. So let me mention guardians. This is another very intrusive thing to have. This is a person who's been appointed by a court to have custody over another person. So in Iowa, it might be different in other states, but in Iowa we have guardians and conservators. Those are separate things. So the conservator does the finances, the guardian handles the person. Technically, we could have a different person as a guardian and a different person as a conservator. But typically, if someone's looking out for another person, a ward, they might be both. They might be both a guardian and conservator. It really just depends. But we could have one person who's a guardian, one person who's a conservator making those decisions. The guardian is for the person, custody of the person. So the terms are the guardian, that's the person who has custody, and then ward, again, just like conservator, that's the person over whom the guardian has custody. This involves, just like a conservatorship, a petition to a probate court. So this is going to be someone is saying that another is so impaired that they can't take care of themselves, and I need to step in and make those decisions and be able to do that. So they can do things like help protect the ward's living arrangement, meals, property, things of that sort. provide for their educational needs, order services for them. Healthcare decisions might be made if we don't have a medical power of attorney in place, and they need to be made. Well, a guardian can make them. Although some decisions might require a court order, so like major surgery or changing the ward's residence, that might still require the court to bless that decision and approve it. But the guardian is generally going to be able to do that. Some advantages to having a guardian: there's some oversight, just like as a conservator files reports with the court, so does a guardian. So reports are going to be filed. Some decisions require that approval, like I said, surgery, residential changes, things of that nature. Guardian doesn't just get to decide every little thing. They do have duties to the ward. It needs to be, decisions in good faith, in their interest, things of that nature. Disadvantages, again, just like with the conservator, it's very intrusive. Guardians can decide certain things in spite of a ward's wishes. The ward might say, I'm perfectly safe living at home. I don't think I need to be in a nursing home. The guardian says, you're really not safe. I'm sorry, but your mental illness is really interfering with your ability to not, do X, Y, Z. Something's going on where they're not safe. And they might actually physically harm or kill themselves if they live alone. That would be one of those things where the guardian's probably going to win out if he petitions the court and says, Mr. Judge, we need to have this ward placed in a place where they're going to be supervised because they cannot live alone. The ward doesn't want it, but we need to do that. And the guardian's probably going to win that one if the guardian has good evidence that that's the case. This cannot be revoked or amended by the ward. So like with a power of attorney where in writing you can just do it, or with a medical power of attorney where you can orally revoke it. Guardians, if the guardian's not doing what they're supposed to be doing, we're going to have a petition filed in court to replace that guardian, or argue that we don't need one anymore. Maybe we're not incapacitated. Maybe we've recovered from our mental illness or coma or whatever it might be. We're going to have to file a petition in court. That's probably going to cost money, right? Because we're probably going to have attorneys involved in it. And it might be contentious. It might be one of those cases where it costs us a lot of money to do. So I'm going to go over a scenario right now to highlight why I think it's so important that we take care of this really basic legal planning. So here's the scenario. John was struck by a car while passing the street. He is currently in the hospital and he's in a coma. The doctors are not sure whether John will ever wake up from the coma and will not know for some time. John is single and has two sons, Alan and Andy. Alan and Andy do not get along. John does not have any close friends and the rest of his family is distant. John's bill payments, including his mortgage, car, and utilities, are due to be paid in a week. What could happen? Well, what happens if he doesn't have some of those things that I've talked about? He doesn't have a financial power of attorney in place. He doesn't have a healthcare power of attorney. Doesn't have a living will. Hasn't nominated a guardian and conservator. Let me go back and mention that really quick because I think I forgot to say that. In your power of attorney documents, the first thing I talked about, financial power of attorney, you can nominate who you would like to have as your guardian conservator should you need one. Okay, that doesn't guarantee you're going to get that person that you nominate, but it is very strong evidence to the court that you would trust whatever person you nominated to be your guardian and conservator. So if ever it becomes necessary to have one, the court's going to put a lot of weight into that. And the court's going to say, wow, that person you must have really trusted. Maybe your son or your daughter. In this case, maybe Alan or Andy as one of them as opposed to the other. So that's something that I really think that people need to be doing. So let's say he didn't do that in this case. He didn't nominate someone and he doesn't have any of those documents. So let me just go through what could happen. So there's no durable financial power of attorney to pay the bills. Remember I said that are due in a week. And no one has legal authority to access his bank account, let's say. So John may be in a coma for a few months. We don't know. He could be gone for several months and can't wake up. We don't know. The doctors don't know right now. So let's say the bills are piling up and creditors start to sue him. Maybe they get some judgments against him because no one has the power to litigate. He just has a default action or something like that. I don't know. So Alan and Andy don't agree who should assist John or how to assist him. John never executed a healthcare power of attorney. Okay, so no one's there to make decisions about what should be happening with John. So let's say Alan files a petition to become John's guardian and conservator so Alan can access the bank get the bills paid, and make necessary decisions about health care. And then let's say Andy mistrusts Alan, and he files a separate petition, and he says, Alan's not going to honor John's best interests or wishes. They both hire attorneys. They're going to argue about who's best to care for John. Both lawyers get $2,000 retainers at least, I guarantee you, to argue the cases on an hourly payment basis. Let's say $200 an hour. That's pretty basic for attorneys. Pretty average, I would say, probably for Des Moines. The court appoints a guardian ad litem in addition to those two attorneys that are going to be battling. And that guardian ad litem is going to be paid from John's estate later. Whether he doesn't even know this is happening, okay? John's distant relatives who are not close with him, remember I said they're not close, they start taking sides with Andy and Alan. They start saying, well, I agree with Andy. No, I agree with Alan. And the attorney fees start to go up as the contention goes up in the case. It's a really contentious case, let's say. And it's really argumentative. It's really expensive. The judge ends up appointing Alan, let's say, to be the guardian conservator. Reasonable attorney fees are going to be assessed against Alan's estate because that's what happens. If we petition to have a guardian conservator and that petition is granted, the fees, reasonable fees, are going to be asserted against the estate of the ward, that person who needed it, okay, whether they wanted it or not. They're going to have to pay for it generally. So let's say that happens. Obviously, the money could have been used for a lot of other things, but no attorneys got paid that day instead. John's health takes a turn for the worse just after Alan's appointed guardian and conservator, and the doctors are convinced John's going to die soon. Should life-sustaining procedures be used to prolong death or not? Now, that's the next question. Now, they're already fighting about these other things, but this pops up now. Now, John's guardian, Alan, guesses. He doesn't know. He guesses that John would have preferred that doctors stop life-sustaining procedures. So Andy's really angry because he lost in court, and he doubts that Alan would have wanted that. He disagrees. He says, no, he wouldn't have wanted to end that. He would have wanted to have a chance at all costs, let's say. So he's livid, and that Alan decided that his father's ready to pass away. Half of John's family agrees with him, half of them disagree. So now they're all fighting about whether that should be the case or not. So let's say John passes away. A significant fraction of John's estate went to Alan's attorney and John's guardian ad litem. His family is now completely divided. Planning the funeral is the worst thing ever. They can't even get along on that, let's say. So all of that happens. Okay, this happens. Okay, it sounds kind of like I'm just trying to think of the worst thing that could possibly happen. We can avoid that. I mean, that's possible for any of us in this room. We can avoid that by just doing this very, very simple and relatively inexpensive legal planning for our futures. We can say what we want. So let's say with legal planning, John had done all these documents here that I already talked about. So here's a slide about kind of some of the things I already talked about just now. What would have happened if he did plan? Let's say he did plan. So John executed a power of attorney document. He gave Andy the ability to act on his behalf in financial matters if he becomes incapacitated. And he also nominated Andy to be his guardian and his conservator in that document. Remember I said you could nominate your guardian and conservator in your power of attorney document? Then he takes that financial power of attorney document to John's bank and he pays John's bills with it. He pays it on time. So there's no problem. There's no creditors suing him, nothing like that. They don't have to wait to have a conservatorship set up by a court, months if it's going to be a contentious case. He just takes that document to the bank. He pays the bills. Non-financial medical decisions eventually need to be made. Let's say he still goes into he's in a coma and it looks like it's now terminal. He's going to pass away. And we need medical decisions made. There's no need to have Andy or Alan fight over who needs to be guardian. Let's say he appointed Andy to be the guardian. So Andy is going to make those decisions. Even if the other brother disagrees with that, the court's going to look at his power of attorney document nomination and say, oh, I see a clear preference here about who John would have wanted. It's going to make it a little more clear who should be making that decision. So let's say later John doesn't recover and his health worsens. John's doctors are convinced he will soon die and a decision needs to be made about whether life-sustaining procedures will continue or not. So the doctors open John's file. They see he executed a living will. It says clearly right there, John would not prefer that. He would want the life support removed if that were the case. So that's what happens. They don't have to argue about it. They don't have to guess. They see it right there on the document. The family, there's no rumors. There's no accusations. That document, the family knows he didn't want that. So that's what happens, and a lot of contention is avoided. So that's the best case scenario. We have all this done. Hopefully it goes that way, okay? Because we want to avoid that first events that I mentioned that when he didn't plan. So the last thing I'm just going to mention here, that when we do our advanced legal planning, very basic planning, we're going to preserve our money because we're not going to have attorneys who are going to have to be fighting over about these sorts of things in court. We're going to preserve our intent because it's clear what our intent is if we put it down on paper and we do it correctly and we execute all our documents. And it's going to preserve our family because our family doesn't have to guess and fight about what we would have wanted. They know what we want because it's in our documents and we already have it planned. So with that, I think I'm right on time, so I will stop there. Does anyone have any questions?
Yes.
Okay, go ahead.
I have a financial power of attorney for my mother.
Okay.
And she's not to the state yet. I kind of just work with her on stuff. I don't have to do a whole lot myself.
Okay.
But I've been told that if I need to finalize or sign her tax returns, I need a special power of attorney from the IRS.
Okay. I'm not aware. That could very well be the case. I'm not quite sure on that. I would just, they might have a special form. Some government agencies do that, just like with the representative payee, where a special form needs to be filled out. I would just follow whatever they tell you that you need. I'm not sure if that's technically required or not, but if that's what they want, then...
If the government wants it.
Right. If the government wants it, do it. So, any other questions? What about Fort Dodge? You should probably ask them.
Andrew, this is...
Oh, go ahead.
I have a question.
Go ahead.
I have a friend who says she doesn't need a power of attorney. She has a living trust and that takes care of it. Is that true?
The trust, I guess it kind of depends a little bit on those facts. I don't know that I want to discuss your personal case in front. We don't have confidentiality in here. I'm not sure on that. So I think it really depends what the trust is set up to do. If it's just for her benefit only, that trustee is probably going to have some duties as well as a power of attorney would have. It sounds like she's has some planning done. She's probably if she has a trust like that, she's probably been advised by an attorney, and there's probably a reason that she has that, which I don't know why that she has that. So it very well could be fine in her case, but I just don't know if that, for that particular case, if that's good or not.
She says it takes care of afterwards too. Is that correct?
Absolutely. That's a common reason, one of the reasons why a lot of people get trust, because you can avoid probate and just have your assets transfer immediately after. So that could be part of why, but it might be set up. I don't know if it's set up for just her benefit or what exactly the reason is for it being set up. There might be other ancillary legal reasons to have that trust. So I simply don't know without knowing more of the facts. But trust is something you should explore for sure. I would go to an attorney about your specific case. I just mentioned power of attorney because it's such an easy thing that we can all do in case we get incapacitated and we don't have a trust, or we don't need a trust because we don't have a ton of income, let's say. Power of attorney is probably going to be your way to go. Any other questions?
It's kind of an opinion.
Okay.
Recently, I went to an attorney after looking at the Alzheimer's advisory thing, and I asked for the documents I needed for my husband has Alzheimer's, and I have the power of attorney and the second one on the list. Oh, I'm sorry, but I did not get the other.
You got cut out. Sorry, I got the first half of the question. You said you didn't get your documents you wanted, but I didn't get the last part.
I'm sorry. Not the...
Okay, I think you're cutting out again. I'm not hearing anything. Want to try it one more time?
I just was wondering, when you go to an elder attorney and you ask him for the documents you need because your husband has Alzheimer's, should he not suggest what you have just suggested? Because now I have 2 documents, but from what you're saying, I'm not in good position.
Okay. Sounds like there's some sort of dispute with an attorney of your husband. I don't know if that's what you said, but okay, husband. I would encourage you to call our hotline because I don't know why that would be the case. Again, I don't want to talk about personal cases in here because we're not confidential, and I can't establish a client-attorney relationship by advising you specifically. But generally speaking, I'm guessing someone else is going through that case. Generally speaking, that there is probably a reason. Maybe there's some sort of dispute or I'm not quite sure what's going on. So I would encourage you to call our hotline, and maybe we could talk with you specifically about that to figure out what the attorney is saying about why he or she is withholding the documents, and maybe we can come up with a better way. I mean, we could maybe even able to reach out to that attorney for you I would encourage you to call in. Our pamphlet is towards the beginning of our book. I think on the second page has our number. So, or just talk to another attorney if you don't want to talk to us. Should we ask Fort Dodge?
Yeah.
We're going to ask Fort Dodge now, and then I think we need to move on because we don't want to. I think we're over time.
Okay, we have 3 questions. One of them is on the healthcare power of attorney. You talked about that it could be revoked by the principal, even orally. Does that include if a doctor has said that you can't make your own medical decisions?
Yes.
Okay. And then does Social Security recognize a conservator?
That is a really good question. I don't believe they do. I think they still need to have a representative payee. I'm not positive on that, though. I think if that was a question about that, I think they would, if you called them, they should be able to tell you that directly. I don't know if people are confused about that or why someone had a question about it, but I'm honestly not sure if they would. I'm thinking you probably still need to have a rep payee, but I'm not sure.
Okay, and the last question is, you talked about the financial powers of attorney duties. When is it, so if there's concerns that this isn't happening, like you talked about somebody being able to ask for the records, so when does that happen and how could that happen?
So I think I interpreted that question to me. So if someone wants to look into what a financial power of attorney is doing, how do they ask for an accounting? Is that fair? Okay, I'm seeing hands.
Yeah.
Okay. So it's the principal can ask for it. Now, obviously, the principal could be incapacitated, so that might not be possible. So let's assume the principal can't ask for that accounting. A government agency that's tasked with protecting that person, like, I don't know, DHS or something like that, could ask for it. So if there's a concern about financial exploitation or elder abuse, then that could be brought to the attention of DHS or someone else like that. They might be able to ask for an accounting. If an attorney has been hired for that principal, that's like a fiduciary relationship. So if there's some fiduciary for that principal, that fiduciary should be able to ask for it. So, I mean, as an attorney, if someone came to me and said, I think someone's being exploited and I want an attorney for that person, I would then say, well, I'm that person's attorney. Give me those records. I'd like to review them. But if it doesn't fall into those categories, if it's just, another person who's not a fiduciary, not the principal, not a government agency, we're not going to have a right technically to ask for that. Now, if we have some evidence of exploitation or something like that, and then we file a court case in district court, we could get them through discovery, but that's just going to be through the litigation process. It's not going to be a right given to you by statute. Now, the power of attorney could also say, I would prefer, in addition to the statutory accounting procedure, I would like my sister or someone who's not included in the statute to be able to ask for that accounting. So that is a very good question, because if we have someone that we really trust that we want to be there in case something goes wrong and we want them to be able to get those documents, we could put that in the document and say they should have the right to ask for an accounting as well. All right, I think I'm going to stop there because we're going over time, and I don't want to go over the next speaker's time. So we're going to give it like 2 or 3 minutes, a quick break, and then we'll start again. Thank you. My name is Andrew Cederdahl.